Welcome everyone to MSBA's Coffee and Conversation series. We are here today with Judge Stacy Mayer, who is a circuit court judge in Baltimore County. She also serves as chair of the Legislative Committee of the Judicial Conference. And we are really glad to have this conversation and continue our partnership and dialogue with the judiciary and advocacy as well. We have several other series sessions coming up and that we've already done in the past. All of those are available on our advocacy page and our YouTube channel. So please do check those out when you get a moment. Next week, we will have the next state's attorney for Baltimore City, Ivan Bates, who will be joining us as well. So please mark your calendars for that. And I'll turn it over to former Senator Zirkin. Thanks.
All right. Thank you, Shally, and good morning, everyone. And Judge Mayer, it's great to see you this morning.
It's great to see you as always.
It's an honor to have you here on the Maryland State Bar Association's Coffee and Conversations. We've been doing these with a lot of legislators and advocacy groups and so forth to educate the tens of thousands of bar members about kind of how the legislative process works and all the different players in it. But I'm really excited to be here with you, and so let's get started. So, you and I have known each other for a long time, but for those who may not know you, can you kind of give us a little bit of your history, how you came to sit on the circuit court for Baltimore County?
Like from the day I was born, or just
the day you were born? All the way back.
Well, I guess I started my legal career in the Baltimore County State's Attorney's Office as a law clerk. And so I worked during the day and went to school at night at the University of Maryland. And it's interesting how your legal career starts. You think it's going to go one way. And if you had to plot it out linearly, it probably would not end up the way that you think it's going to end up. You meet people along the way that end up helping you in your career and shaping some of the things that you do. And in this case, I was a law clerk, and then I became an assistant state's attorney in Baltimore County. I ultimately went to the Howard County State's Attorney's Office and was a prosecutor there as well for a number of years. And then when I was in the Howard County State's Attorney's Office, one of the people with whom I worked in the State's Attorney's Office as a law clerk was working in the governor's office, doing public policy on essentially public safety issues. And he was leaving, and he, knew me from the two of us having previously worked together and suggested me for the position when he was leaving. I had never done legislation before. And if I think about it now, and I had known what I was getting into, I probably wouldn't have taken the job because I didn't realize
every day.
Right. I didn't realize necessarily how, what I was getting into, but the opportunity to work on public safety legislation statewide was really exciting for me as somebody who was a practitioner. And I ended up sort of right before the session going down and interviewing with the person who at the time was the chief legislative officer for the governor. And he had never hired somebody without legislative experience either, but we hit it off and he hired me, and I started right before the legislative session. And I did that drafting and advocating for legislation, public safety legislation, and then a bunch of other areas for 5 years. And then ultimately I was appointed to the district court in Baltimore County. I sat there for 7 years. And then not this past February, but the February before, I was elevated to the circuit court. So that's the short synopsis.
Well, we're going to hopefully talk about a lot of those different experiences, starting with the legislative experiences. But I think it's important for people to know, I think it's a pretty huge testament to you that you worked for Governor O'Malley in his legislative office and was appointed to the district court by Governor O'Malley, and then appointed to the circuit court by Governor Hogan.
Yes.
Which I think is pretty, you think about kind of the hyper partisanship, but it speaks to you just, how you cut across all of the political spectrum, and how people from all sides of the aisle respected your legal acumen. So I think it's important for people to understand that. But anyway, let's go back to the legislature for a second, because that's where you and I work together, and let's start there. And we're going to talk about judicial conference and all the rest, which is really important. and important to members. But in your 5 years in the governor's legislative office, you said you worked on public safety. Was there anything in particular, any issues that stand out to you, things that you worked on, good, bad, indifferent, good stories, things that you did there and before you got elevated to the bench?
I have a lot of stories.
Ones you're allowed to tell.
I was going to say, none of which I will share on this webinar. No. I think, for the members, just sort of first putting aside some of the policy issues, just the experience. I'm so very grateful for the experience that I had working down there. Like I said, it's not something that I would have anticipated in terms of where my career would take me. But having had the opportunity to work in the legislature in that way, drafting legislation, understanding legislation, looking at all different areas that I both practiced in public safety, but then other areas that I ended up picking up like healthcare and insurance and things like that. It really helped me incredibly to learn areas and to understand statutory construction and things like that for the job that I have now. But also, it helped me realize how hard the job is for legislators, particularly, you and I worked together when you were a member, and then ultimately you were a chair of JPR. The amount, I think it's easy for those of us outside of the legislature to criticize some of the decisions that are made. But then when you get down there, you realize just how many topic areas they cover. 1,000 plus bills are introduced every year. And it's impossible for the legislators who are citizen legislators to be an expert in all of those areas. So it's really important that members, like, for instance, members of the MSBA, get involved in the session and the legislation that's before, because the legislators really need to hear from experts in the area. Think about the practice that we all had as lawyers. You might have had a general practice, or you might have sort of had a specialized practice area. But even within that specialized practice area, you always called somebody who knew more about a certain area than you did when you had an issue. And the legislators who are down there have to cover this wide breadth of topic areas. They can't possibly be experts in all of those. And the people that are down there every single day in Annapolis have a really big voice in the crafting of the laws that we all are going to have to adhere to. So if the lawyers who are experts in the area don't get involved, it's hard for our legislators to make good decisions.
It's true. It's I was always surprised, and we'll talk about this because of the importance of MSBA and the judicial conference, the increasing importance, because the number of lawyer legislators, even from when you and I were there to today, has diminished greatly. And so, in practice areas, you just don't have the expertise, you just don't have people that have been in
Right.
courtrooms before to understand the issues, some of those issues at least. So you dodged it a little bit. Any good story about a legislative, one or two legislative issues that you were involved in, things that you're particularly proud of during your time down there?
I have a lot of different areas. I'll say, in terms of my role now, my rules of professional conduct preclude me from going too far into talking about, areas that I probably feel personally proud of, because I don't want to necessarily indicate that I feel a certain way about any particular policy, because obviously it would not affect my decision making on the bench. But there were a lot of really big topic areas that we covered when I was down there that fell within my purview. And I would just say that there were a lot of really big changes that were made when I was down there that were, I don't think I could have done it more than 5 years, because it was exhausting. And they were hard. We did some pretty big changes. The marriage equality we worked on when I was down there, the repeal of the death penalty. We had a lot of firearms legislation that I would say was probably the biggest public policy fight and the most contentious issue that we dealt with, because of people's, very passionate views on the issue, which, those things were really very hard. And we also had healthcare reform. So Obamacare was coming through, and we had to, prop up our framework for federal healthcare legislation when I was there. And, I didn't know really anything about the healthcare field other than, picking the box on my insurance through, for my personal family decision. So those types of things were pretty big areas that were, it was a lot of fun and also very, very challenging.
Okay. Well, I will move on from the legislative process then. But so you, at the kind of after 5 years of working for Governor O'Malley down in the legislative office, you were appointed to the district court for Baltimore County, and you sat mostly in Essex. Is that right?
I did. So for those of you who practice outside of Baltimore County, we have 3 district court courthouses in Baltimore County: Catonsville, Towson, and Essex. And I did sit in all of those areas, but mostly almost every day I was in Essex. That was really my primary assignment, which I loved. It's a great courthouse.
So you went from the district court to the circuit court. Kind of differences for you in terms of experiences. Obviously, everybody understands the differences between the 2 courts, but kind of your own experience and differences between those two experiences for you.
There's a lot of overlap in terms of the cases that you have. Family law obviously is a huge area that I didn't practice in the family law context, although we have some as a district court judge. You make family law decisions in the context of a protective order in terms of temporary custody. So that's a huge difference that I didn't have in district court compared to circuit court. And obviously jury trials, but I had done jury trials previously as a prosecutor, and so I was really glad to have that experience. It looks a lot different when you're when your only concern is making sure that you have a fair and impartial jury, and you're not necessarily trying to get certain people or make certain decisions about who ends up on the jury as an advocate. So it's really interesting. I mean, the jury trial process is fascinating. I think our jurors take it really very seriously. It's very heartening to see how seriously they take it. And then, of course, we've had COVID through all this. So in Baltimore County, we've been picking at the American Legion, which has been interesting.
I was there fairly recently and got thrown off the jury immediately. So there
Did
you
you?
go.
Oh, you were
Yeah, they wanted no parts of me. So so
they just don't know you as well as I do.
So now in your role as a circuit court judge, that's moving into kind of a really important topic for MSBA is how to affect legislation. And you are the chair of the Judicial Conference's Legislative Committee. I found, just an editorial comment, I found during my time in Annapolis, that was one of the most important groups, in fact, maybe the most important groups that I had to deal with, or that I sought their advice on almost everything, because I thought they had a really important voice on all matters legal. And so I wanted to hear from them more so probably than any other group. Tell not me, but tell the members who are watching, like, for those who don't know, what is the Judicial Conference's Legislative Committee? How does it work, and kind of your role in it?
So I'm the chair of the Judiciary's Legislative Committee, and it's comprised of a number of members, other judges, and it's judges statewide on both, really on all of the courts. So we have members from district court, circuit court, and we have appellate judges. And again, who really have both, we have, in any event, we have judges statewide, which is very important because each jurisdiction kind of has its own idiosyncrasies. And so ensuring that you have geographic diversity as well as all other measures of, diversity, so that you really have a broad spectrum of representation on the committee, it's really important. But we have a process where every bill that gets introduced ends up being vetted through the judiciary's committee process. So we have a staff person who pulls all the bills, submits the bills of interest to the topic committees within the Judicial Council. So, the Domestic Law Committee, the Juvenile Committee, the Court Technology Committee, each of them has a legislative team and they review the bills. And then each of those committees submits their positions on the bills that have been introduced to the legislative committee for our consideration, because there may be different committees that have competing, some people think this is a good idea, some people don't, and they have competing views. And then we have to rectify that on behalf of the judiciary. And then we submit position papers and bring up areas of concern that we see in legislation that's been proposed. And we do that. We meet weekly throughout session. We have emergency meetings if we need meetings more frequently than weekly. And we really are very actively involved to the extent that we weigh in when needed, but we also very much recognize our role and the legislature's role. And we're very respectful of that in the sense that policy is the function of the legislative branch, and we do not take positions on policy because we, of course, respect the separation of powers doctrine and recognize that our role is not to make public policy. That's the role of the General Assembly. So
I was gonna ask that. So how do you, I mean, because obviously those issues merge a little bit, it's the
Yeah.
line between the law and policy is not all that easy to tell. Like, how do you make the determination as to which bills you're going to get involved in? Are there specific areas? Like, I would assume the judiciary doesn't usually take positions on healthcare, for example, or insurance law, or
well, it depends. We might. I mean, it might be that we recognize, we may recognize that there's a conflict within statutory provisions. And so it's necessary, even if we think it's a policy determination, to at least bring that to the committee of note to their attention, so even if it's a policy decision, this is a policy, we take no position on the public policy, but we bring to your attention this potential conflict, or the fact that this conflicts with some rule of civil procedure or something like that. So we will do that, bring those things to people's attention or the committee's attention, but any policy decision, we make clear that that's within their purview. But there are, like you say, sometimes it can be a little difficult.
Right. Yes. So let's talk about some examples. I mean, so for example, there's one going on right now, which is really big, and actually has been big since my very first year in the General Assembly. I think there was legislation about the election of circuit court judges, and something about since you had to go through an election. And Maryland's process, for those who don't know, I'm sure everybody does, but district court is appointed, the courts of appeals and the special appeals are whatever, or the Supreme Court, whatever they call it now, is
Supreme Court of Maryland and Appellate Court of Maryland as of December 14th.
Yeah, I killed that bill many years in a row, in much of the chance. So, but the circuit court judges have this appointment/election process, and it's convoluted and controversial for some, and some people absolutely love it. And so it's been a topic of conversation, and I know you're involved in that. So as an example of maybe how the judicial conference may or may not get involved in an issue, can you speak to that one?
Sure. I mean, anything that, deals with the court's administration, we constitutionally feel that falls within the chief judge's purview. And so we take positions on sort of the court administration. And I think this is one of those topic areas where we have waded in terms of a position. And so it has generally been our position, and we have both put in position papers and testified, and previous chief judges have testified before the General Assembly on legislative changes to change circuit court judicial elections to retention elections like the appellate courts have, instead of contested elections. For this upcoming session, prior to session, Chief Judge Fader decided to put together a work group to study really holistically judicial selection. And he named former legislator, with whom I know you're familiar, Kathleen Dumais, who's now a circuit court judge in Montgomery County, who also just went through an election, and retired Judge Alex Williams to co-chair this work group to study judicial selection, really to take a broad, holistic academic look at judicial selection in Maryland, as well as in other states, to see if what we're doing makes sense and if we're doing it in the best way possible. And so that work group got started. The work group has met now, and there are a lot of different members on it with different positions. Former Chief Judge Mary Ellen Barbera is on it. Former Law School Dean Don Tobin is on it. Billy Murphy is on it. There are judges who have been appointed and had contested elections. There are judges who ran for contested election on it. There are members of the public on it, advocacy groups, a really broad spectrum of people, and they're looking at it in general. We've had people come from the Brennan Center, from the Sandra Day O'Connor Center to talk about what what other states do, what works in other states. And it's been very interesting. We just recently had a public hearing the day after Thanksgiving, where we heard from members of the public about their positions. And we've gotten a lot of feedback, and we haven't yet gotten to the point in the work group where we formulated recommendations. Right now, it's just a study, and you have to do that first before you obviously come up with a recommendation, or what would have been the point of all that work. So we'll see where it goes, but we really hope that people weigh in. I hope that members of the MSBA weigh in. And you can make all of this information is on the judiciary's website. And if you put in work group to study judicial selections, you can pull up all of the materials, the agenda. You can see who the work group members are. There's a lot of very interesting information that's on there about both what other states do and about the makeup of our courts and our process. So I hope that people avail themselves of that information. It's really very interesting, and weigh in.
So I know that our president, MSBA president David Shapiro, is on there as well. Is it best for MSBA members to funnel their commentary through him, or is the committee also looking just to kind of have lawyers from across the state weigh in on their own?
I mean, I think it's good. I think in general, more participation is better. Obviously, if it's from, the MSBA as a position, you may want to funnel your information just so that there's one point person, but honestly, members should weigh in individually as well. It's really important that people's voices be heard on this, and all views be taken into account. I have been surprised, frankly, at some of the issues that people have brought up in this process. I was sort of just thinking that this was about contested elections or not, retention elections or contested elections. But I have to say the feedback that we've gotten really has been more about the judicial nominating commissions and people's views about their makeup. And that's been a surprise to me.
It's interesting. So I put in bills on this issue because I remember when I was first elected, there was a Supreme Court, a Court of Appeals case. I'm going to keep calling it the Court of Appeals. The Court of Appeals case, I think it was Sussman v. Lamone, and it was kind of a sidetrack from the to have or not to have elections, but an independent voter who happened to be on a nominating commission was disenfranchised because of the way that the process worked. And so independent voters, I always thought, if we're going to have these things, you should at least make sure everyone gets a chance to vote, because it could get, if it gets done in the primary, then it's over.
Right.
But we can never get it done. I mean, we could never, in 20 some odd years, you could never even make that change. Everyone agreed with that, but could still never get it done because you couldn't agree on how to do it. So what do you think? And I'm not asking you to kind of, tilt one way or the other, but at the end of the day, does the judiciary just continue to being against the contested elections, or do you think there's going to be a more comprehensive kind of recommendations about nominating commissions and the elections coming out of this commission?
I think, I because we're still sort of in the process, I don't know 100% where it's going to go, but if I had to guess, at the outset, I would have thought that this would have been just about contested elections versus retention elections. Given the feedback that we've received and the information we've received, I think that it's more likely that this will be a more holistic approach. The fact that people keep bringing up the Judicial Nominating Commission and the process has been interesting. I think there has been a lot of feedback about the specialty bar associations and their vetting, which is so very important that candidates be vetted. and that the people who participate in that vetting process have the ability to weigh in. And there's been a lot of sort of feedback that they don't feel that necessarily that their position is heard by the overall Judicial Nominating Commission at times, and that there's a desire to ensure that there's a greater diversity of opinion and background on members of the Judicial Nominating Commission. So I don't know. I mean, we're really just at the time in which we're looking at this issue, but I do know after our last meeting that was discussed. You know, the composition of the Judicial Nominating Commission for people who don't know is entirely dictated by the executive orders that are generated, and those obviously change over time. And so in any event, there's some discussion about that.
Interesting, really interesting. Well, we will certainly keep our eye on it. It doesn't have to be done this year because any changes would have to be done by the Constitution anyway, or not necessarily nominating commissions, but
Exactly. Well, right. It depends on what you do, but but absolutely the contested election is, that would require a constitutional change. And so this is the first year. I mean, obviously that wouldn't be on the ballot until 2 years because we just had an election, and and we'll have a lot of new faces in the legislature this year. We have a new governor, and so it probably doesn't make sense to do it this session, given that it wouldn't be on the ballot if anything passed that was a constitutional amendment until the following year.
really interesting. Let me do a different issue, and let me just couch it by saying I'm not asking you to give your opinion on it because I know you are not allowed to do that, but just in terms of in terms of the judicial conferences, legislative committees process.
Mhm.
There was a bill 2 years ago. It was on the ballot this year, actually, and it was a court issue. So it changed the amount in controversy
Yes.
from, I think, 15,000. It was supposed to go to
Yes.
30,000 with the
Change to 25.
concurrent,
Mhm.
but it made it 25, and 25 to 30 is concurrent, which seemed
Right.
a little odd to me as a practitioner, but nonetheless, that was the
I
legislative
think that was the compromise. The bill didn't go in that way. It
right.
seems a bit interesting to me too, but for some reason that amendment was made in committee.
Right. So putting that aside, right, putting that aside for a second, is that the type of issue? Because that is obviously a court process. Like, I guess that's something that both the district and circuit court would have interest in. How would the judicial, how would your legislative committee look in general at an issue like that? Is that purely a policy decision, or would the legislative committee weigh in and say, look, guys, this final product may not make sense from a policy, or do you stay away completely from the policy? Like, how do you attack an issue like that?
It's a good question. I can't remember now because we review so many bills. I can't remember if we took a position on that or not. I think I want to say that we supported that change, but I don't remember. I can't remember, frankly. I could probably look it up, but I can't
So,
remember if we took a position on that or not. I don't remember. I mean, ultimately, what the amount in controversy is the decision that the legislature can make, what they want to do in terms of where they draw the line. But even things where it might be a policy determination, something like that, there are committee members who often will ask us, does this, as you say, affect the court's operation? Is this going to cause a problem in terms of, can you absorb this in one place or another? And so we will end up weighing in on those particular issues, because there are times too where it has a fiscal impact, and we have to, for each bill that's submitted, we have to submit information to the legislature about any fiscal impact, and that has to be considered. So there are times when, even if it's a policy decision, we weigh in on those types of court administration. But this is a particular issue where I think everybody can absorb this without there being any need for any additional monies or anything of that nature.
got it. Another one like that may have been, and again, not to ask you to talk at all about your position or even the conference, but expungement was another one. It's a policy call, had a fiscal impact.
That is one that it very much has, depending on how it's drafted and how it's done, may have a fiscal impact, because it's interesting. There are times when a hearing is required, when some of those things you sort of wish, can't they just be written in without a hearing? And because sometimes it appears as if, there's not really, well, in any event, that they should be granted, but you still have to hold a hearing, and the additional, court resources that are expended for that, that has a fiscal impact. The other thing on the expungement, depending upon how the bills are written, and we ran into this on a number of different bills, is they required not just an expungement of the conviction, for instance, but a expungement of a particular aspect of the record. And so for the clerks to have to go in and pull essentially the record and, expunge only a portion of that, that just has a very serious logistical cost that we have, it requires additional manpower. And it may be a public policy decision, which absolutely we stay out of, but the need to have a person actually go in and wade out, sort of essentially expunge a portion of a record, as everyone can understand who has to do something like that, redact a certain document or something in their practice, it requires manpower.
It is an interesting, it's fascinating to listen to this. And I hope people understand the complexities of it, because you will often see, for example, I remember the unit rule was
Yes.
That was the one, I guess, kind of what you were alluding to, where people want to expunge things that get null prossed. If they get convicted of one thing, the record stays on for everything else. It's a policy call about whether or not you think that
Yep.
the public has the right to know what they were accused of, even if it was null prossed. But from the judicial conference's perspective, it's a logistical, quagmire to figure out how you would actually physically do that, how you would be able to go in and redact certain things.
That came up too with the aspect of marijuana in the terms of old court records. So whether or not marijuana was 10 grams or, fell within above or beyond that limit. Well, previously we didn't draw the distinction at that amount. And so in order to determine, for instance, whether you could expunge that, somebody had to actually go into the record where it was originally just charged as possession of marijuana and make a determination the way that the law was written as to whether or not that particular charge actually was more than 10 grams or not. And it just required manpower. Again, we took no position on the public policy, just the way that the legislation was drafted required a person to actually go back into the individual record. And so that, that just requires manpower.
Right. Very fascinating stuff. I remember, because crimes that are no longer crimes are
Right.
Automatically expungible, but was it 10
How do you
grams or 11?
How do you determine that? Because they're, like you said, crimes that are no longer crimes. Well, somebody has to make a determination as to what that is, because they were defined different statutorily previously. So, again, understand the public policy perspective, but how do we actually implement that? I think that's the most important aspect of MSBA being involved and the members being involved in the legislative process. People who actually understand how things work on the ground weighing in. Otherwise, the legislators, how could they know?
So let's move on. Some other issues maybe this year that the conference may be looking at, is it more of a proactive thing, reactive thing? Are there any issues about, for example, technology in the court? I know that some folks in prior conversations have brought up cameras in the courtroom, or more efficiency of using things like this, like Zoom, for court processes. Are those things that the judiciary will weigh in on proactively, or just kind of wait until the legislators put in their own bills to figure out how to jump in?
Each year is a little different. I mean, there's times when we have particular issues that we're spearheading, and we actually are asking a member to introduce legislation on our behalf. And a lot of times you'll see that with, for instance, when we have specialty courts or something like that we are introducing, and we need legislative authority for that. That's something that we'll do. This session, I don't think that we have any real big ticket items that we're going to the legislature on. It's likely mostly going to be reviewing legislation that members put in and weighing in that regard.
How about the last couple of years, judicial transparency, for example, another issue. Again, not asking you to weigh in on the public
Yeah,
policy of it, but just did the judiciary weigh in on that, and if so,
we
how?
did.
And, what
We
did
did.
you find that to be effective?
I think it was. I think it was. I mean, I have to say, I think as you said, and I'm glad to hear you say that when you were a member and you were the chair, frankly, and we miss you there, um, seriously, Senator. But in all honesty, the members have been very responsive. It's been very good. And again, we can all have sometimes cynical views of the way that, as people say, the sausage gets made. But if we don't play a part, an active part in making our voices heard for the members, then they just don't have the information that might be helpful to them to make a decision as to how these laws affect Marylanders. So they've been very responsive, frankly, when we have either testified or put in a position paper or spoken to members about some of the issues with judicial transparency. The Sentencing Commission had some very serious concerns about the way that the legislation was drafted, and there are a lot of interesting studies about the sort of sometimes the way which public's perception of sentencing affects decision makers. And so, each case, every judge is making a decision with all the multifaceted factors and considerations that they have to make. It's hard to drill that down to a data point. And that's always a difficulty. So the Sentencing Commission definitely weighed in, and we did as well. Ultimately, legislation was passed, but it came out in a very different form than it was introduced, and we thought that was fair.
That's great. Well, I want to be cognizant of your time because I know you have to jump on the bench at some point in time. I guess one kind of question that's been interesting to me. I served in the General Assembly during Judge Bell, Judge Barbera, and I didn't have an opportunity to serve under Judge Fader. How have things changed?
And Judge Getty.
Oh, Judge Getty, of course. Yeah, my
Who you
former
served with,
my
right?
God, my former seatmate, both in the House and the Senate.
I know. I knew you would not want to forget him. He was just so important that you, right?
Well, he was important in my formative years, but we won't get into that. But and Judge Getty, I'm so sorry. So I guess one of the questions, I mean, how has it changed? I mean, they're all very, very different personalities, different ways of doing things. And you were with all of them as well, I believe, right? During O'Malley's time, Judge Bell was there. So
Yes.
you've served with, in some capacity, all four of them. How have the operations of the Judicial Conference, Legislative Committee in particular, or anything you've seen related to the legislature changed under their leadership?
It's interesting. As you said, everybody has their own personality, and that's just human nature. But honestly, the structure has remained the same in terms of the Judicial Council and the committees. I think the court is very respectful of the process and recognizes the importance of having that structure so that the committees can each weigh in, who have sort of the subject matter expertise, and then have that vetted by those committees and have that then submitted to the legislative committees. The process has actually stayed almost exactly the same. I came in, I was appointed in 2013. And I immediately got on the legislative committee. And then in 2017, I became vice chair and then became chair. And so I've sat through one big change is we all meet via Zoom instead of telephone conference, but that's just technology's benefits these days. So we can screen share the bills. But honestly, the process has been very similar. And I would say all of them have been really wonderful about setting up a committee structure that makes a lot of sense and benefits from the expertise of the members of the judiciary. Obviously, there are certain issues that require the top person, the head of the organization, to weigh in, because ultimately the way that the Constitution is structured is that certain things are determined by the chief. Administration of the courts is one of those things. And so there are certain areas in which they may weigh in particular, but generally the structure has been the same. One new addition is I think Chief Judge Getty is going to be back on our legislative committee, even though he's retired. So we're going to benefit from him rejoining our legislative committee. He was previously a member, and then when he was chief judge, he had other duties. He couldn't be on the legislative committee anymore, but he is back on the legislative committee this year, which is incredible because his experience obviously is always needed and warranted as a former member. We're so happy to have him.
He was when I first got elected, he was my seatmate in under Joe Valerio. So and I was, it doesn't matter. Joe was married with many children, and I was single at the time. So he was consistently advising me as to my my social life, in addition to all legal matters. So very important words of wisdom from Chief Judge Getty.
Right.
So I guess before we end, one of the most important things, the reason we do these coffees and conversations, is to make sure that members not only are educated on the process and different aspects of it, but also to understand how they can best influence. It's obviously important for them to get involved, but you have had a breadth of experience in the legislative world, both in the executive branch and now in the judiciary. I guess as a general final question, for members who are watching this, how can they most effectively get involved, in your opinion, either through through the MSBA, or just as individuals, citizens who want to influence legislation?
I mean, I guess if I was a member, how would I do it? Basically, I mean, I would probably contact you.
And I'll tell them to contact you.
Right. I think knowing who to contact is part of the greatest. I mean, that's really one of the things, because the people who know who to contact know, even if you're not the person to contact, who the person is to contact, who's most relevant in making these decisions in this particular area. So I think members should, be involved both through MSBA and the MSBA's advocacy, which is critically important, that there be some structure that funnels through the MSBA. What is the MSBA's position, which I know the MSBA weighs in on. But then after that, I don't think people should overlook contacting their local elected official, because I think people don't often realize how important that is. The local elected officials want to hear from their constituents. And if you contact the person that you're voting for and let them know what your particular position is, if they don't have purview of the subject matter, they know who it is, and they'll be more personally invested because you vote for them. I think it's really important.
Well, looking forward to seeing kind of the upcoming General Assembly. A lot of new members, obviously a new executive branch, new treasurer, new controller, everything, new general, everything is new. So, I would say just editorially, the role of the MSBA and the Judicial Conference is vitally important, maybe more so now than I've seen since I first got involved. So it's great to have you here, Judge Stacy Mayer. Great that you are the chair of this legislative committee. We're in good hands with that. And it really just an honor to have you here for one of our coffees and conversations. I thank you so much for being with the Bar Association.
Thank you for having me. It was a lot of fun.
All right. Shally?
Thank you so much, Judge and Senator Zirkin, for this conversation. We learned so much, and I know this will be an ongoing conversation and partnership. I also wanted to put in a plug here today for MSBA Day that's coming up on January 24th, when all of our members are invited to join us, legislators, and important Maryland leaders in Annapolis. So more to come on that. And thanks everyone for joining, and have a great day.